Well, I think we're ready for our regular programming now, so I'm going to turn it over to our program director, Kathleen Donnelly, who will introduce John.
Great. Thank you so much. I am honored to introduce John Tandler tonight. He is a member of Sherman and Howard LLC, a regional law firm in Denver. And he's going to discuss the history and development of U.S. copyright law tonight. He works with many clients, developing, maintaining, and monetizing intellectual property assets. He has a wide variety of work that includes copyright and publishing, rights counseling, preparing contracts, licenses, and wide variety of projects centric to books and magazines. So we're lucky to have him here tonight to speak to us. So with that, if anyone has questions during the presentation, you can put them in the chat and I will try to jump in and ask John the question. He's fine with asking questions as we go throughout the presentation. Or if you have one and just want to raise your hand and jump in, that's great too. So with that, I'll turn it over to John. Thank you very much.
Thank you, Kathleen. Good evening, everyone. Just some housekeeping. Kathleen, do you want me to screen share or how do you want to do this? Do you want to let me?
I think if you want to try it, I think that's going to work better. But if it's not working, I can certainly give it a shot. I have it pulled up on my computer, so.
And this is Margaret. I have made John a co-host, so he should be able to screen share. There we go. He can.
Okay. Let me get oriented a bit here. Okay. Can everyone see the PowerPoint?
Mm-hmm.
Can everyone see me? Okay, because I can't see me, but if you can see the PowerPoint, that's what's important. Let's just try this. Okay. 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 Thank you so much for attending this program this evening. I really appreciate it. I always admire when writers and authors and people in the literary industry take their personal time, their volunteer time, and gather together to talk about publishing in literary works. I teach a fair amount, and this is something that always impresses me. I think it's fair to share how I came about presenting to you this evening. You can see my very complex set of notes here based upon coffee with CJ Sapor, who asked me to attend tonight. Truth be told is that CJ is the president of our homeowners association. And when we had our picnic here this summer, he saw me about 15 feet away from the beer keg. And he saw that I had had a beer or two in me, and he approached me and we talked about what I was doing, and he asked me to teach. And what could I say? I was a little bit under the influence, but I'm drinking ginger ale tonight, so it's all good. CJ asked me to teach about the general history of copyright in the United States, and from that talk a little bit about the lineage of rights an author creates and how they can be transferred and monetized with various persons. And then from that, I'm going to talk a little bit about the exclusive rights of an author and what's known as fair use law. Please feel free to, if you have a question, let me know. As I said, I'm not seeing the chat box at all, frankly, so I'm not sure, but Kathleen can let me know.
Yeah, I'll keep an eye on the chat box for you.
Okay. So the constitutional premise for US copyright law is actually in the Constitution. The framers of the Constitution had the aforethought when they set forth the powers of Congress to enumerate that Congress has the power to promote the progress of science and useful arts by securing for authors and inventors the exclusive rights to their respective writings and discoveries. So the original Constitution of the United States gave Congress the right to create legislation which protected the rights of inventors and creators. Congress did just that in the first Copyright Act, which was adopted in 1790. It was a very small, rudimentary act and very limited in scope, only providing for protection for books, maps, and charts for a very limited of time, 14 years, with a renewal period of 14 years. That act was amended several times to create the scope of works created, to provide for derivative works, and actually ultimately to establish the Library of Congress and the Copyright Office. After that, after the Act of 1790, literally 119 years later, the Copyright Act of 1909 was adopted. That act, if you can see my screen, this is the whole 1909 Act. Can people see that? Just speak up. You can see it's literally on 23 pages, and you can see how antiquated the print is. Are you all seeing this?
Yes, I can see it.
An act to amend and consolidate the acts respecting copyright.
Wow.
Then 70 years later, almost 70 years later, on January 1st, 1978, after several years of congressional testimony and drafting and legislative drafting, Congress adopted what's known as the Copyright Act of 1976 that actually went into effect on January 1st, 1978. And the 76 Act is primarily the body of copyright law I look at today, we look at today to advise, to comply, to advise clients as to copyright law, to do analyses under copyright law, and to comply with as a copyright lawyer. And that act is augmented by many things. First of all, the Code of Federal Regulations, there's a series of circulars that the Copyright Office issues on various topics, which practitioners must adhere to, if you will. And what's known as the Compendium of US Copyright Office Practices, which again is a very, very detailed technical procedurals manual when you're dealing with copyright registration with the US Copyright Office and all matters regulatory pertaining to copyright. These are all available at the Copyright Office website at www.copyright.gov if anyone ever wants to look at them. And then of course there's federal common law, the case law that augments all of this regulatory landscape. And I'm going to talk in a little bit about some copyright cases, about works that will be popular, that works that you have heard of. This, by the way, is a paperback version of the 76 Act. Just you can see a little different.
Hey,
Now
John,
a bit about,
sorry, I didn't mean to interrupt, but is your PowerPoint supposed to be changing pages? It hasn't changed pages yet. I just wanted to make sure.
I'm really glad you told me that. Of course it is. Yes, it
Oh,
is.
oh.
So am I still on the first page?
Yes.
Okay, I'm very grateful that you told me that. All right, let's try this again.
Oh, there we go.
Do you have the new page now?
Yes.
Okay,
Well,
so
macro chronology of
Yeah.
US copyright. Okay.
okay. And by the way, for any, thank you so much whoever mentioned that. My goodness, thank you so much. And if you do want a copy of the presentation, I'm happy to send it to you. I don't know that it's really, it's not, a, well, anyway, if you'd like a copy of it, I'll be happy to send it to you. Now, so let's take a moment and talk about the two big agencies in the United States that deal with copyright, the Library of Congress and the actual Copyright Office, which is a United States regulatory agency. The Library of Congress and the Copyright Office, as I said, was established by federal law. And the Library of Congress is essentially the research library that serves Congress. It's the oldest federal cultural institution in the United States. It's one of the largest libraries in the world. It houses the Congressional Research Service. And as I said, it supports Congress. And it also houses the US Copyright Office. The Copyright Office is the regulatory agency which interfaces with the public in dealing with copyright. So the Library of Congress really interfaces with our lawmakers. So does the Copyright Office, but the Copyright Office is designed to serve the public. Here's the mission statement of the Copyright Office. Can everyone see that slide? The US Copyright Office promotes creativity and free expression by administering the nation's copyright laws and by providing impartial expert advice on copyright law and policy for the benefit of all. That is what it does. I deal with that agency a lot. And far be it from me to not include some photos. So here's some photos of the Library of Congress. The building, by the way, is a very special building. It's in the middle of Washington, D.C. And you can see that it's a gorgeous, gorgeous, amazing structure. And essentially, it was designed by architects in Washington, D.C., who adopted an Italian resonance plan, John Smithmeyer and Paul Pels, which was finally approved by Congress. There's a whole lot of literature on the architecture of this amazing, amazing building. And to be super clear, these are my photographs, all right? So my point in telling you that they're my photographs is not that they're good, because they're actually not that great, but they are what they are. But I didn't have to get clearances to use them. And as a copyright lawyer, I'm into clearances. So these are my own, but you can see what a gorgeous structure it is. And if you do have the opportunity to go to Washington, D.C. as authors, it would be super interesting to visit there. That's the main reading room in the Library of Congress. And the Copyright Office is in a building adjacent to the Library of Congress. So back to the Copyright Office, which is the regulatory agency which examines applications for registration. Have people filed registrations for copyright in this group? Speak up. Has anybody filed registrations for copyright?
Yes, definitely.
Okay.
I haven't.
Okay. How about the author who's got 4 books that just are getting contracted for?
I assume my publisher takes care of that. Yeah.
Does your agreement provide for that? Does the agreement require the publisher to do that?
You know, I think it says in the front page that I own the copyright. I'd have to
Yeah.
look.
Let's take a moment and talk about that in a few moments. So the Copyright Office, as I said, examines applications for registration, registers claims, records assignments, does everything relating to registered copyrights. Does everything relating to registered copyrights. It examines several 100,000 claims a year, and in 2020 collected more than $33 million in registration application fees. The Register of Copyrights is Shira Perlmutter, who's a brilliant lawyer, copyright lawyer. And the staff is about 440. And right now, the Copyright Office is undergoing a huge updating plan with all of their IT, serving the public, impartial expertise, enhanced use of data. So they're really right in the middle of or right actually at the start of a whole plan to upgrade and update the Copyright Office. This is another picture from my visit there in 2016, little sense of card catalogs. And here's an assignment that was done in 1904 from one of the card catalogs. And here is Ingrid Abbott, a longtime employee and now executive at the U.S. Copyright Office, Assistant Chief of the Literary Division. And as a lawyer, I call the Literary Division in the legal counsel's office when I have questions about work that I'm doing with the office and I want some guidance ahead of time. Okay. Now let's talk a little bit about the law. So copyright comes into existence at the moment of creation and fixation of your original work of authorship into your computer. So when you create your detective novel, when you type those characters, when you create those stories in that authorship, copyright comes into existence at the moment of creation and fixation into your computer or on your handwritten notes, if you're writing handwritten notes. What I'm speaking this evening is not protected by copyright. Maybe it is because we're recording it, but absent recording it, it would not be fixed in a tangible medium of expression. You do not have to register copyright with the U.S. Copyright Office for it to have legal protection. However, registration with the Copyright Office provides much greater legal rights in the event of an infringement of your literary work. So if you who are writing, and it's wonderful and fantastic, writing these books, 9 books, 8 books, 3 books, 4 books with the publisher, or another 4 books with the publisher, and you're putting these books out into the stream of commerce, the hurdle to copyright registration is very small. It's very easy to do. And honestly, you should be doing that. If I get a telephone call from an author or a photographer that says, hey, my work's been ripped off, it's been unlawfully infringed, all of a sudden I see the photograph and a poster and I didn't authorize it, one of the very first questions I'm going to ask is whether that literary work or that photograph, what have you, has been registered for copyright with the U.S. Copyright Office and when. That's going to impact my initial analysis of the rights the person has. It does not mean that if you do not register your work with the U.S. Copyright Office, you do not have legal rights. What I'm saying is that registration gives the copyright owner much better legal remedies, greater legal rights in the event of a third-party infringement, in the event of an unauthorized use. That's not on this slide. That's just basic information about registration. What's on this slide is who owns that original work. And in all instances, unless there's an unless that's applicable, it's the original author of the literary work. So each of you, when you create your books, you're the original owner of copyright. If someone creates a work made for hire, so for example, if one is a freelance writer or a computer graphic designer and fits the requirements for work made for hire as a freelancer or an independent contractor, then that work can be owned by the commissioning party. So if I engage one of you to help me write a chapter book, and each of you create a chapter for a collection of mystery stories, let's take the hypothetical a bit further. If I commission each of you to write a chapter or a mystery minute for a compilation of chapters I'm preparing, then in order for me to own copyright, I would have to have an agreement with you, a work made for hire agreement, that you would assign copyright over to me and it would meet the requirements for independent contractor work made for hire. So as you can see in this slide deck, in the case of a work made for hire, the employer or other commissioning party owns copyright to the literary work. Now, copyrights are like, in a way, pens. They can be transferred, they can be sold, they can be leased, they can be licensed, they can be inherited. So all of the copyrights, even the statutory copyrights, and what I mean by statutory copyrights, that's the copyright in your literary work when you fix that into a tangible medium of expression. So for those of you who are writing multiple books, in your planning and in your estate planning, you should know that your copyrights are an asset, an intangible asset that can be carried forward to your heirs, and your heirs can continue to have the benefits of works that you're published and the royalties therefrom or the earnings therefrom. You can see under section 201D in that slide, the transfer of a copyright may be transferred in whole or in part by any means of conveyance or by operation of law, and may be bequeathed by will or pass as personal property. So if you die intestate, meaning without a will, then those copyrights are not going to be properly disposed of, but they will be transferred by the laws of intestate, like your other assets.
John,
now, I'm going to skip one slide real quickly. No, I'll actually talk about work made for hire, and then I'll talk about exclusivity. Did someone have a question?
they did have a question, John. Lori wants to know, does a work have to be finished to be copyrighted? And at what point can you protect a work?
When you write that first chapter, when you write that first page, it's really what rises to the level of a work of authorship. So for example, if you're writing a mystery novel and it's going to have, it's 300 pages as an example, and you write I don't know how you compile if you write the whole thing and then rewrite it, or if you write a chapter at a time and 150 is done of the total 300. People probably work in very different ways. But however you work, that original manuscript or portion of that manuscript, to the extent it is an original work of authorship, copyright subsists in that whether or not it's complete. Statutory copyright protection subsists in that whether or not it's complete in that original work of authorship. Now, let me peel that away a minute. If I say, see the dog go to the backyard, see the dog go to the backyard, that's not copyrightable. That's just a short phrase. There's no original authorship in that. There has to be a sine qua non, a minimum level of original authorship in everything that we're talking about. Okay, that's the first thing. And the second thing is that if Barb writes a story about the dog going to the yard, okay, and then I write a story the next day about the dog going to the yard, that's not protectable. Copyright protects original works of authorship fixed in a tangible medium. It doesn't protect ideas, it doesn't protect themes, it doesn't protect concepts or methodologies, it doesn't protect a storyline unless it's really super, super close and it's substantially similar. It protects works of authorship. Now, I want to take another minute and talk about work made for hire, because I really flew through that. But here, this slide is a perfect definition, because it's really from the Act, of work made for hire. It's an employee preparing a work within the scope of his or her employment, or a freelancer. That was the example I gave, with a work that's specially commissioned. And the example I gave was a chapter book, which would be a collective work. So an employee creating, like a newspaper photographer, creating photographs within the scope of that photographer's employment duties, the newspaper likely owns copyright. Okay. Whereas if someone is a freelancer, meaning not an employee, but an independent contractor, then in order for the commissioning party to own the copyright by that person, it has to be one of these kinds of works, a collective work or part of a motion picture. and an agreement specifying that. So this is a good slide for understanding the rudiments of work made for hire. And by the way, referring back to CJ's mystery moment about Mr. Himes, is it's H-E-I-M-Z, CJ? Did I hear that correctly? Is it H-E-I-M-Z?
H-I-M-E-S.
H-I-M-E-S, thank you. So he became, at one point in his career, a screenwriter. And in California, where the screenwriters primarily were employed in the 60s, work made for hire, if you characterized someone as an independent contractor doing work as a work made for hire, under California law, that person, contrary to most other states' laws, was entitled to certain kinds of employment benefits like workman's compensation insurance and unemployment insurance. And those laws that protect screenwriters, and they do, and other freelance types of creators that where their work is characterized as work made for hire, those types of persons under today's California laws get certain types of employee benefits, as I said, unemployment at workman's comp. And those laws emanated from the 60s, where screenwriters who were doing work made for hire were poorly treated, and they did not have the benefit of those employment laws. And those what those laws are intended to address, to kind of protect independents working on a work made for hire basis for film studios. Now,
Cool. Hey, sorry, John, we have a couple more questions if it's okay to, or do you need to keep going, or, okay. Quick question, is it true that titles aren't copyrightable?
Generally, yes. Yeah, titles, it's certainly under US law. Under US law, titles are not copyrightable, period.
Okay, great.
Titles can have, and titles, the other thing is, titles are not registrable as trademarks with the United States the US Trademark Office. So let's take an example, Gone with the Wind. It's a very, very famous title. You cannot register Gone with the Wind as a trademark with the US Patent and Trademark Office. However, if I published a book and called it Gone with the Wind, and I've got an example of this later on, I'd probably get sued because the book is so famous that people say, oh, it's Gone with the Wind. It must be from, Margaret Mitchell. It must be that book. So there would be confusion. But in answer to your question, titles are not copyrightable under US law. Next question.
All right, the next one is, what about works written by co-authors? Who owns the copyright there?
Under the Copyright Act, the definition of a joint work is, I'll read it, better yet. They own it together is the short answer. So co-authors that intend for their work to be a joint work of authorship own the work together. And of course, I can't find the definition really. Here it is. A joint work, this is in section 101 of the Copyright Act. A joint work is a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. So if you have two authors who are really writing a novel together, and their intention is that their thoughts, their works of authorship be integrated and merged into a whole, then they jointly own copyright to that literary work. And as such, they have a statutory duty to account to one another for any proceeds they get therefrom. So if Craig and I write a book together and I go off and publish it and make a gazillion bucks, I've got to share half with him. And Craig, same thing, buddy. If you do it, you got to share half with me. I'm there. Okay, next question.
All right, the next one is from Sharon, who said, Stan Lee originally wrote his comic books like Spider-Man as work for hire. but he ended up getting paid more once the comic books earned so much money. How was he able to do that?
The answer is I really don't know. The
Okay.
smarter answer is that people use the term work made for hire in a very loose way. 95% of the time, and I don't think I'm exaggerating, when you hear people, non-lawyers, use the term work made for hire, what they're really thinking is that it means it's done on a non-royalty basis.
Okay.
They're not thinking of the actual definition under the act. They're thinking that it's in terms of industry vernacular. And to be clear, I've been working in publishing law for over 30 years, since 1988.
Wow.
So people use the term, if someone in a cocktail conversation says, oh, he did it as a work made for hire, she did it as a work made for hire. Honestly, what I think they're saying, and I actually make sure I understand, is that the person did it on a non-royalty earning basis. So the question about Stan Lee, and I can get into a lot deeper in the weeds, if you will, but the question, did he really do it as a work made for hire? And even if he did it as a work made for hire, you can still do something as a work made for hire and do it on a royalty basis. You can still, the concept of doing the legal framework or structure of doing something as a work made for hire, meaning as an independent contractor where copyright is assigned over, you can still do it on a royalty basis. I don't see that being done, but it can be done. So in any event, I don't have a super good answer to your question. I'm asking questions to your question, for which I apologize.
Okay.
One
So,
more, should I go on?
we have one more, and then we can move on about recipes. Are recipes copyrightable?
You know, recipes, formulas, methods, formulas and recipes as formulas are generally not copyrightable, to the extent that a recipe creates its own work of authorship and the textual language of the recipe ultimately rises to a work of authorship. And certainly a recipe book can be copyrightable as a compilation of pre-existing content, but the recipe that boils down, pun intended, to here are the ingredients, here's how you make it, not so much.
All right.
Okay.
Great. Thank you.
Okay. And again, I want to be clear about that. Some recipes, if they really rise to the level of unique authorship, they might be copyrightable. And again, a whole recipe book, I don't have one here I don't have a recipe book here, but the whole compilation, the whole authorship that goes into a gorgeous recipe book and the textual aspects of that book. I actually gave a gorgeous recipe book to clients this year as holiday gifts that's published by a client of mine, and it's absolutely copyrightable. But like little ingredients to make up this beautiful tomato soup, that part is not copyrightable. But there's a lot of photographs and textual information and authorship in the assemblage of that material that is protectable. Okay, just to elaborate there. So what is copyright? What does copyright really get you? This slide is a replica of Section 106 of the Copyright Act, and this is the exclusive rights that copyright provides the copyright owner. And it's basically the right to reproduce, to create derivative works, which are adaptations. In the case of literary works and motion pictures, to perform the works. And a motion picture is a derivative work of a literary work. So when you talk about one of your books ultimately becoming, you know, a motion picture being created out of that, that is, first of all, the screenplay is the derivative work, right, of the original manuscript, and then the motion picture is made off of that. And all of the rights have to be licensed and granted. So again, you can see in the case of literary sub 5, in the case of literary works, to display the copyrighted work publicly, in the case of sound recordings, to perform. And the most important part of this slide is the bottom language in green. Oh, which is that these rights are divisible. So Craig and I can create this literary work and we can publish it. We can self-publish it. We can hopefully license it to Scheinman and Schuster to publish it. And if we want to do an audio version with Barb's audio publishing company, we can license her the audio rights. And then if we want to have Lori or Sharon take the film forward for us, we can license the film rights to them. We can take this bundle of rights that attach to copyright and take it to different places. These rights as to an individual work are divisible. They can be licensed to different persons for different purposes at different times under different arrangements. Okay. So I mentioned this earlier, it's not necessary for a work of authorship to have copyright protection. Statutory copyright comes into existence upon fixation. Here are the benefits, though, to registration if you have an infringement, if you have an unlawful taking or reproduction. You always must register to file and maintain an action in court. If you're successful, you can get your attorney's fees. And if you're successful, you can recover statutory damages, which means it's a fancy term for saying you don't necessarily have to prove your lost profits through the bad infringer. There are formulas in the Copyright Act that enable a copyright registrant to take advantage of those formulas in assessing a damage claim, a damage award. So again, for our clients that regularly publish books, whether they're self-published authors or publishers or a video producer or graphic design work, we encourage for those types of works that are put out into the stream of commerce where people are going to see, read, consume, potentially duplicate, that those works be registered for copyright with the US Copyright Office. Different answer for the person who calls up and says, I'm creating source code for a computer program that no one's ever going to see the light of day of. Because source code unto itself is confidential, and although there are provisions in the Act that deal with preserving confidentiality, that's very different than talking to someone who's got a book published. And the Electronic Copyright Office is the method of electronically getting into, oh, I can see the chat now, getting into electronic registrations with the office. It's not, to finish on this point, I say it's simple, it's not rocket science, but at the same time, when I do a registration of anything, I go through it extremely carefully and use eco-login. You can get an account, you can do kind of like a dummy registration, if you will, to get familiar with how the software and completing the software works. And although it's not difficult to do, when you do it, you want to be very careful about it and make sure you've completed the fields carefully. And if necessary, call the information office, the Copyright Office, because once you press send, it's there. You know, it's tough to change and amend. Plus, in relation to that, you go ahead and file 2 copies of your literary work, your detective work, by uploading them as part of this registration or sending in hard copy. You can do it that way as well to the Library of Congress. So when you complete that registration, you've started the process of registering your literary work for copyright, and you've, in accordance with US law, submitted for archives 2 copies of your book, whether it be hard copies or electronic, with the Library of Congress. So it's actually pretty cool. Let's see. Any questions on that? And I'll go on.
We do have a couple questions, maybe not on
Okay.
that, but Sharon asked, she said, Section 106 seems dated in its language. Will copyright law be revised in light of new media like Facebook, blogs, podcasts, Instagram, etc.?
the copyright laws are constantly being applied and interpreted to deal with social media and different media. And that's done through court cases, regulatory pronouncements, office circulars, and practice. The copyright laws are antiquated in many respects. I don't know if I would say that about Section 106. I've had to deal with 106 in areas where I felt it was a bit antiquated, but sometimes you look at the language carefully and it's not as antiquated as you might think. So I'm positive at some point the 76 Act's going to be, I mean, it's been amended to be super clear many times since 1976. It's 50 years old now, right? So it's been amended to provide for computers, to provide for the Digital Millennium Copyright Act, which is Section 512 of the Copyright Act, which was not in existence in 1976. The DMCA is intended to deal with the internet and the liability of internet service providers. The copyright was amended to deal with computers under the Cantu amendments after in the late 70s, early 80s. So it's constantly being amended. It absolutely needs updating in many areas, and it will be. Whether I'll still be practicing, we'll see. Okay, is that helpful?
I believe so. And Sue Hinken wanted to know, does registration with the Writers Guild of America give you as much protection as a copyright?
No.
Okay.
It's not even, and it's no.
Okay, great. And Lori asked, what do you tell your authors about the proliferation of websites that pop up and deliver exact copies of ebooks that are copyrighted? Seems like no one can keep up with these sites or get them taken down.
You know, I don't deal a lot with that firsthand. I mean, basically we do see, I have a matter in my office right now where we had a client coming out with an audiobook, and pardon me, and a literary book has been being published for many years. There's an audiobook for it. They're coming out with a second audiobook, and all of a sudden they found someone had recorded the literary book. Someone had taken their literary work and they recorded it and created a competing audiobook. It's unbelievable. In that case, again, kind of what I said is the first question is, are you registered for copyright? It doesn't mean that you don't have rights. It just means that you can write a much tougher takedown letter. So the answer is, in the global sense, is when that occurs, these websites are lawfully required to take down infringing works, lest they're put on notice that a work is infringing, then they have secondary aiding and abetting liability. So the practice standard with most websites that publish works is, if you comply with their takedown procedures, this is a generalization, and you can demonstrate you're the owner of copyright, you're the owner of the rights to that work, and it might apply to a trademarked article as well, a counterfeited article as well. That's a trademark problem, a Lanham Act problem. But the point is, these sites, whether it's Amazon or any number of other ebook sites, and maybe some of these offshoots too, typically will have takedown and comply with their takedown procedures. They're required to do so, because if they don't, they can, as I said, have secondary liability. So our experience generally is that if you track the bad stuff, the bad goods, the counterfeit goods, the unauthorized copies, and you follow the takedown procedures, our general experience is that that works get taken down. And again, you're much better off, always better off, being able to write a takedown notice, having a copyright registration to show them you own the copyright to the book in question.
Great, thank you.
Okay. Now this slide, may I go on? Everyone good? Okay.
Yep, we're all good.
So this slide is new to the Colorado chapter of the Mystery Writers of America. It's new to me because CJ said, can you talk about, what did he say? He said, can you talk about the lineage of rights? Talk about continuum of rights granted from the agent to the publisher based in copyright. That's what my notes say, CJ. So I created this slide. I don't know if it's a good slide. It may need work. It's actually 2 slides. But the way I look at it, and first of all, there's the, so these are examples of licensing lineage to literary rights monetization. That's what I call this slide. Examples of licensing lineage to literary rights monetization. Now remember what we talked about. Who owns the copyright, right? Who owns it? You. And then we talked about these exclusive rights. That's what we're talking about. And so we're talking about ownership, rights, and how they get, where they move to get monetized. So these are just examples. You may have more. Author to an agent, and then the agent to the publisher. An author directly to a publisher. A self-published author to a distributor. A self-published author to a bookseller. I take note of, if it was Kurt who said he saw a book in B&N this week. I don't know if Kurt has a distributor or if somehow B&N picked it up directly. Author to consumer. You guys can sell books off your websites. That's another example of lineage to monetization. Here's another one. Author to agent to publisher. Publisher to distributor. Distributor to bookseller. Bookseller to consumer. Right? That's the traditional one. And then I went ahead and I wrote out, well, bookseller could be, bookseller could be either a print book, ebook, or audiobook seller. Then I thought you should all know that a distributor, the word distributor in publishing is very, again, it's kind of like work made for hire. Distributor does a lot more than distribute books. I work with distributors. Distributors can perform sales and distribution, pick, pack, and ship functions, do print book manufacturing, POD manufacturing, ebook conversions. So distributors can perform lots of different functions. And they're distributors that are suited to small self-published authors. Here's another one. This really relates to rights. Author to agent to publisher, agent to foreign rights agent. So this is the scenario where the author takes its right, her rights, his rights to an agent sells, licenses the rights to the publisher, but the agent retains the ability to sell foreign rights. So the publisher gets the right to publish print book rights, ebook rights, US English language rights, but the agent can say, you know what? I have contacts in France. I have a subsidiary rights agent that's fantastic. I'm going to keep those rights and not let the publisher exploit them and not pay the publisher royalty to exploit them. Here's another one, author to agent to publisher, publisher to foreign rights agent. So for example, you might license rights to Simon & Schuster, and Simon & Schuster might have a foreign rights agent that it loves and it's fantastic. So the difference between these two is that an agent goes directly to foreign rights. The second one is where the publisher goes out to foreign rights. Foreign rights are important. The romance publishers the romance authors that I've come across in my work have made lots of success in licensing foreign rights, licensing their works into many different languages and really successfully monetizing them. And then here's one, author to agent, agent to film producer. Remember, an option is not a purchase. So when a film producer picks up a literary work, most of the time, not all the time, most of the time, it takes an option on it. It doesn't actually buy it. It takes an option on it that lasts for a period of time. And then if the producer can really make a film out of it, then they actually go through the real contract to buy all the rights. And when I say buy, I'm using that term a little loosely. They're actually licensing the rights. buy is the vernacular, but they're actually licensing those rights under Section 106. Remember, I said they're divisible. So Barb can do the audiobook and Paramount Pictures can do the film version. Okay, so those are my lineage slides. Now, I wanted to show you, and then we're going to talk about a couple of cases. I wanted to show you, this is a literary agency representation clause. It comes from one of my own agreements. And you can see it's where the author sample agency provision, author appoints the agent and the agent accepts the appointment to be the exclusive agency and representative for the primary rights and the ancillary rights. Very simple. It's not a complicated clause. And then this is a publishing grant of rights, sample grant of rights provision from the author to the publisher. So even if there's this grant of rights from the author to the agent, if the book gets placed, there's going to be this, not exactly this language. Publishers have their own forms, but this is a grant of rights from the author to the publisher. To sole and exclusive rights to exercise the rights as defined, dramatic rights, e-rights, literary rights, and merchandising rights throughout the world to publish, print, promote, transfer, license the rights to third parties. And I defined literary rights there. So I'm just trying to give you a little sense of this lineage whole concept. You know, author to agent, agent to publisher. This is author to agent. Okay, the ability to negotiate the rights. And then if the book is placed, this is the author to the publisher.
And Mike had a question about licensing. He said, licensing isn't abandonment of the author's copyrights, correct?
Correct.
Okay. And then Lori wanted to know what the difference is between rights and copyright.
Copyright is a bundle of rights. Copyright is the glass that holds all of the rights. Copyright is one name of an intellectual property. There are 4 types of intellectual properties: copyrights, trademarks, patents, and trade secrets. Copyright is the word that represents the bundle of rights that we're talking about tonight, particularly in Section 106, as to a work of authorship. And to be clear, a work of authorship can be a book, a photograph, a musical score, a master recording, a screenplay, a motion picture, a work of art, a sculpture. Characters can ultimately have copyrights under certain conditions. It can cover many, many different kinds of photographs, many different kinds of things. Patterns, wallpaper patterns, unique, if there's enough authorship, probably not a good example.
Okay,
This
great.
is where, to the person who asked about, is copyright giving up, is licensing giving up rights? No, this is though. So here I put in a sample assignment provision. So here, I'll go back to this. Here, this is a licensing provision. Author hereby grants to publisher the rights throughout the world to deal with the book. That's what this provision says. And I define rights. This provision says author transfers and assigns to publisher all right, title, and interest in the book and all rights under the Copyright Act. Publisher will own all right, title, and interest in the work and the copyright, and the publisher may register the work for copyright at publisher's expense and publisher's name. This is a complete transfer of copyright to the publisher. This does not happen a lot, except in academic publishing, technical publishing, not trade publishing, not mystery writing or anything like that. You should not. The truth be told is that however copyright resides, whether it's a license or ownership, the other terms of a publishing agreement are quite important. And if you want me to come back and talk about those another time, I'll be happy to. That's beyond my scope tonight, or we'll be here really late. Now, let me start to wind into a little bit of fair use and starting to be that kind of the last topic we're going to talk about. Okay, everyone with me so far? I see a lot of chat. Should I be looking at the chat? No, we're up with the chat. Okay,
Yep, we're caught up with the chat.
great. Okay, so fair use. This slide is the genesis of the body of fair use law. I already talked about the second portion of this slide that Congress gave, that Congress has the power to provide authors with the exclusive rights to their writings. Exclusive. This clause is the First Amendment, which says that Congress shall make no law abridging the freedom of speech or of the press. So this provides for exclusivity. This provides that the freedom of speech cannot be abridged. So those two things are inconsistent. Do we agree? Or have I lost you?
No,
Too late. Those two things are inconsistent. One says that a writer can have the exclusive right to his work. The other says that there cannot be a law that abridges the freedom of speech. So if someone wants to use some of what I've created under the guise of free speech or the press, arguably that violates my exclusivity. Are you all with me? Okay?
Yes.
Thank you. So what fair use does is that it says that under certain circumstances, we can compromise and satisfy both tenes when the public interest is served by displaying the work in a de minimis fashion to educate, to inform, but only in an amount that doesn't really abridge the rights of the author and impact the rights of the author in an adverse way. That's what the body of fair use law is all about. It's about a de minimis use or some kind of use of a third party work, registered or not, that meets the requirements of Section 107, and as such doesn't materially hurt the copyright owner. That's what fair use is about. And it relates to how the book is used, whether the book is fictional or non-fictional, and other aspects. And in short, because it's late, books that are highly creative have more copyright protection under a fair use analysis. Books that are non-fictional and factually driven, like history books, have a little less. In order for something to be used from a fair use perspective, there has to be some transformative purpose to it. It can't be just a replication of content. And only a small amount can be used, and you cannot impact the rights of the copyright holder. So let me give you some examples of this, because I think it's harder to understand when you're talking about ethereal terms. So let's talk about this case. So does everyone remember President Ford, Gerald Ford? Everyone remembers President Ford, right?
Yep.
Okay. So President Ford wrote a book after he finished his term in office, and it was to be published by Harper and Row, which now is HarperCollins, which is now Penguin Random House. In any event, at the time in the 70s, his book was to be published by Harper and Row. A company called Nation Enterprises, it was a magazine company, got a portion of the manuscript and published it ahead of the publication of the book. Okay, and they published about 13%, close to 15% of the manuscript this magazine got a hold of. They actually stole it, according to the case, and they published it ahead of publication of the book. So you had thousands of people being able to read this magazine ahead of publication, and they may have decided to publish the book or not publish the book. But that was clearly a taking of the literal authorship of President Ford's book. And nations argued it was fair use. But let's go through the analysis. All they did was take it. They just reproduced it. They didn't use it to educate, illustrate, augment another article. They just took it and published it. So there was no transformativeness to it. And that cut against the fair use of the work. All they did was use it. They didn't, as I say, use it in any synergistic fashion. President Ford's book was sort of in the middle of the ground in terms of whether it was creative or factual. It was obviously very, very factual. But one of the areas of the book that they took and they copied was a section of the book that described the scene in President Ford's office, pardon me, at the time, President Nixon's office, when President Ford was vice president, where President Nixon broke down and cried on the eve of either impeachment or resignation. And it was a very creative scene, and it was a very important scene in the book. Which goes to the third factor, which is that how much was used. If you use a de minimis quote or a de minimis paragraph of a big book, that probably cuts to fair use. But if you use a very, very important part of a book, what the law calls the heart of the work, that would cut against a fair use analysis. Here they used this scene from Nixon, and that was deemed to be so critical and important that it cut against fair use and cut towards copyright infringement. And then the last factor is the effect of the use upon the potential market. And because this magazine had published close to 15% of this manuscript that was going to be published by Harper and Row, the court decided that certainly in some measure supplanted the original market for the original book, and that cut against fair use. So that under this example, first, there was no purpose of the publication except to just get it out there. Second, they used something factual, so that cut more towards fair use than not. But they used something extremely critical to the work in question, and it actually ultimately competed with the work in question. So that's a sample fair use analysis. I know it might be a little hard to understand. Maybe it's easy to understand. It's something that lawyers and courts write about, argue about, think about all the time. It's one of the most, it is the most large area of copyright law in terms of grayness and at times ambiguity. Parodies, moving on, are a kind of fair use. All the other elements I mentioned are applicable. How is the work factual or fictional in nature? Is it creative or not? How much content is used? But the parody aspect of fair use deals with the transformative factor. A parody is a literary or artistic work that ridicules the original work in question. That's the transformative factor. That's the synergistic factor. That's factor one. And let me give you an example of this. So everyone's heard of Gone with the Wind. Have most people in this call read Gone with the Wind? Let's have some voices.
Yes, I think I have.
Yeah, I have a long time ago.
Yeah.
Saw the movie.
Okay,
Yes.
me too. So several years ago, an author whose name is Alice Randall created a book called The Wind Done Gone. Has anybody heard of what I'm about to describe in a minute? Has anybody speak up if you've just curious?
No.
Okay.
No.
So Gone with the Wind it's really a great illustration of a couple of things. Gone with the Wind, first of all, is one of the most popular books of all time. It may have sold less copies than the Bible, and by now it may have sold less copies than the Harry Potter series, but it's truly one of the most published books of all time. Secondly, Margaret Mitchell passed away years ago. So to my comment about publishing rights and rights of copyright being transferable, the rights to this book are owned by a trust. And the trust is run by a trustee, and the trustee is a bank. So Alice Randall wrote a book called The Wind Done Gone and published it with a well-known, super respected publisher called Houghton Mifflin Publishing. Maybe you've heard of this company. They're based in Boston. Houghton Mifflin, Houghton. And Houghton Mifflin published this parody of the book Gone with the Wind. And Alice Randall wrote this parody to ridicule and criticize the message that was in Gone with the Wind. Slave ownership, things of that nature. And the estate of Margaret Mitchell sued Houghton Mifflin and Alice Randall and said, this is copyright infringement. You are using so much information, authorship, creative authorship from Gone with the Wind that, notwithstanding your book, The Wind Done Gone, is a parody and criticizes it, you've used so much, there is so much of a taking that outweighs the transformative use and the fair use that would otherwise be available for a parody. And they went to litigation. And actually the case went all the way up to the Court of Appeals for the 11th Circuit. Houghton Mifflin actually lost in the trial court, and the case went up to the appellate court. And let me just read you one or two things from the case. Ultimately, the parody was deemed to be lawful as opposed to unlawful, and Houghton Mifflin was permitted to publish it. Just a quick snippet. The Wind Done Gone, this is from the court. The Wind Done Gone is more than an abstract, pure fictional work. It is principally and purposefully a critical statement that seeks to rebut and destroy the perspective, judgments, and mythology of Gone with the Wind. Randall's literary goal is to explode the romantic, idealized portrait of the antebellum South during and after the Civil War. In the world of Gone with the Wind, the white characters comprise a noble aristocracy whose idyllic existence is upset only by the intrusion of Yankee soldiers and eventually by the liberation of the black slaves. Through her characters, as well as through direct narration, Mitchell describes how both blacks and whites were purportedly better off in the days of slavery. That's what the original book does. Okay. Here's a quote. The more I see of emancipation, the more criminal I think it is. This is the original book. It's just ruined the darkies. Free blacks are described as creatures of small intelligence. So this is what Alice Randall criticized in her secondary book. And again, she was sued for copyright infringement. Let me read one more little passage, and then you'll understand why they sued her. The Wind Done Gone appropriates numerous characters, settings, and plot twists from Gone with the Wind. For example, Scarlett O'Hara, Rhett Butler, Bonnie Butler, Melanie Wilkes, Ashley Wilkes, Gerald O'Hara, all names that you all remember, I'm sure, Ellen O'Hara, all characters in the Gone with the Wind appear in The Wind Done Gone, but she gave them all different names. Scarlet becomes other, Rhett becomes RB. So what Alice Randall did was she did take the names of the characters, the plot setting, Tara, things of that nature, and use them in her secondary work. She conjured up the authorship from the first work that was necessary to convey her criticism and ridicule. Hence, with all of that, the court determined that The Wind Done Gone is a lawful parody under a fair use analysis. Let me give you two more things, and then we'll conclude.
Sounds good. We do have a few questions, but
All right,
let's
I'm happy
finish with-
to stay for questions. I just want to be respectful of your time. I'm fine.
Yeah, that sounds great.
So I want to tell you about 3 more things. First, there's a different case that I just love to talk about involving Dr. Seuss. So this is extremely different than what I just described. This is where someone decided, a publisher called Penguin Books, one of the largest publishers in the world, in fact, the largest publisher in the world today, published a book called The Cat Not in the Hat, a parody by Dr. Seuss. What this book did was it used the rhyming and rhythm of the Cat in the Hat books to tell the O.J. Simpson story. Some authors said, oh, this would be really cool. This cool vernacular and rhyming that appears in the Cat in the Hat books, I'm going to tell the O.J. Simpson story, and I'll read a passage from it. And it's got to be lawful as a parody because it just is. And there was no legal aforethought. Let me explain what I mean. Here's from the offending work. And this was found not to be a parody. The publishers of Dr. Seuss Enterprises sued this publisher, Penguin, on the basis that it was not a lawful parody, that on the basis of copyright infringement. Because remember what I said about what a lawful parody has to have. It has to ridicule or criticize. There has to be a transformative element of ridicule or criticism. Here's the language from the offending, infringing work. A happy town inside LA, where rich folks play the day away. But under the moon, the 12th of June, 2 victims flail, assault, assail. Someone will go to jail. Who will it be? Oh my, oh me. The 3rd page reads, 1 knife, 2 knife, red wife, dead wife. This stanza no doubt mimics the 1 fish, 2 fish, red fish, blue fish. Katz goes on to write, a plea went out to Rob Shapiro. Can you save the fallen hero? And Marcia Clark, hooray, hooray, was called in with a justice play. A man this famous never hires lawyers like Jacoby and Myers. When you're accused of a killing scheme, you need to build a real dream team. Cochran, Cochran, doodle-doo. Johnny, won't you join the crew? Cochran, Cochran, deedle-dee. The dream team needs a victory. So there's no criticism or ridicule there. They just used that which is protectable in Dr. Seuss. They lost. Dr. Seuss wins. I said 2 more things. There's a lot going on in publishing. If anyone cares, this is the weekly magazine of the publishing industry called Publishers Weekly. It, along with lots of other sources, are amazing information sources about what's selling, who's publishing it, breakout authors, what kind of deals are getting written, book reviews. Are people familiar with Publishers Weekly? Do people read Publishers Weekly? How about a response to that one?
Yes.
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 Great. So most everybody. Fantastic. Fantastic. I'm glad to hear that. It, by the way, the company is celebrating its 150th anniversary this year. Yeah, pretty amazing. yes, there is a lot going on in publishing. Last comment, this is a teaching notebook I've assembled because I teach for the Denver Publishing Institute. I'm on the faculty of the Denver Publishing Institute, and I was asked to teach a class next week about something I don't know that much about, but there's so much going on. What's in this notebook is the antitrust litigation between the United States and the proposed merger between Penguin Random House and Simon & Schuster, respectively the largest and fourth largest publishers in the world, in the world. And then the other part of the notebook is the litigation that's occurring relating to the Maryland legislation, the state of Maryland legislation, which requires publishers to sell licensed ebooks to Maryland libraries on terms that are unacceptable. And the publishers, the American Association of Publishers, are taking the view that it infringes their authors' rights of copyright. So there's always litigation, there's always interesting cases. I'm blessed and fortunate to be in this field. I fell into it, but once I got into it, I've enjoyed it so much. Okay, it's almost 9 o'clock. What else can I answer? I've talked a long time this evening, and thank you for listening.
Yeah, John, this has been fantastic. And maybe I'll just pick two quick questions. Well,
Sure.
I think they're quick, and then we'll wrap it up. Rita asked, what is a public domain work?
A public domain work is a work that's not in copyright. It's a work where it was never in copyright in the first instance because under the old act, it didn't meet the requirements for copyright to attach, or the copyright has expired through time. That's in essence what it is. It's either copyright did not attach in the first place or the term of copyright has expired.
Okay,
And
great.
the laws relating to that are complex.
I bet they are. And that'll kind of lead to, we'll make this our last question. How many times can a copyright be renewed and for how long?
Oh, that's a great example of something I won't answer in a presentation or a recording because again, the answers are too complex. The basic answer, it's a good question. The term of copyright, just 30 seconds, used to be, before the Copyright Term Extension Act, used to be 50 years after the death of the author. The most simple rule, 50 years after the death of the author. The Copyright Term Extension Act, the Copyright Term Extension Act extended that by 20 years. But when you have questions about the term of copyright, when it starts, what's eligible for a renewal, how long it could be renewed, I always have to honestly look at the act and apply the act to the specific question. So that's not something I generally answer in a program.
Okay, great.
Okay.
Well, this has just been, I appreciate you staying longer than we asked you to, and this has been
Pleasure.
an amazing presentation. So thank you.
Thank you all.
Thank you.
Oh, that was
Thank
very
you so
good.
much, John.
Thank
That was fantastic.
Very informative.
Thank you.
Good.
Thank
Very
you.
good.
Thank you.
I'm sure we could ask you questions for half a day.
You can have me back.
'Cause
I didn't get my
very
tacos
complex.
tonight, so I'll come back if you want this summer and we'll do something else if you want, whatever helps your group and all of you.
That sounds great.
Meeting.
Thank you so much.
All
and thank
right.
for-
You all be well. Thank you so much for having me.
If we want copies, like you said, you'd send it. How do we get hold of you?
Just
to get
send me
them?
your email. Kathleen and CJ have my emails and I'll ship it out to you.
Okay, thanks.
Yeah,
Okay.
awesome. Thank you so much, John.
Thank you. I'll be well.
Thanks, John.
Bye-bye.
Bye.
Bye.
Bye-bye.